Union South.
I call David Seymour.
Well, thank you, Madam Chair, and it's a pleasure to speak on the Friendly Societies and Credit Unions Regulatory Improvements Amendment Bill, and I want to commend the member in charge, Stuart Smith, for bringing this bill. Many members don't presently have a private member's bill either in the ballot or before the House, and many that do have quite simple and some might even uncharitably say trivial bills before the House. But Stuart Smith has taken on a substantial and quite technical challenge in reforming a very old piece of legislation that is essential to the operation of a significant part of our financial sector, being friendly societies and credit unions. So I commend Stuart for doing so, and I just make another background observation, Madam Chair, that some people believe that a free society is one that consists only of individuals acting independently. Actually, a free society is one where individuals come together and create all manner of institutions to solve collectively problems that they cannot solve by themselves. And this Parliament is one such institution that has evolved over a long period of time to solve collectively a group of problems that are difficult to solve individually. I might go further and say that the Parliament's possibly gone a bit beyond the original brief, but nevertheless that is the intention. And when it comes to friendly societies and credit unions, they are a particular type of institution that people have come together and formed in order to solve certain problems. How do people in small communities, as Jackie Dean recently referred, access financial services that larger incorporated banks may not wish to serve? How do people break through any trust issues they may have with the financial sector, especially after some of the bank failures of last century, to have a financial institution that they feel they can trust? Indeed, friendly societies and credit unions are important institutions in our society that have solved a lot of problems for people, and I commend Stuart Smith for bringing to the House a bill that will improve the legislative framework under which they operate in this country. But I'd also like to speak to Supplementary Order Paper number 40, an amendment in my name, the genesis of which is that while there are many enthusiasts for Stuart Smith's bill, some of them actually based in the Epsom electorate, and I've heard from them extensively, there are also a significant number of credit unions. In fact, they represent about half of all of the New Zealanders who subscribe to this kind of institution, and they are not in favour of being compelled to incorporate. These institutions tell us that in actual fact they will face costs that to some very small institutions will be greater than their annual surplus. There will be significant compliance costs imposed upon them that they cannot realistically bear. And I just asked, Madam Chair, in the spirit of a free society and people being able to form institutions to solve their problems, where is the right in us as a House of Parliament in imposing costs that will be ruinous to institutions that are working for the people? And I put it to people on submitters and my fellow members of the Finance and Expenditure Committee, and also to Stuart Smith when this bill was examined, that actually it might be possible to have it both ways. And so with that background, I present this supplementary order paper, and members may be alarmed at the considerable length. There are actually bills that come before this House that are shorter than the supplementary order paper I'm presenting to the committee tonight. Let me give some explanation as to why it is so important that we put forward a supplementary order paper that modifies just about every clause of the original bill. And the reason for that is that if there was simply to be an exemption saying the requirement to incorporate does not require... Madam Chair.
Point of order, Dr Duncan Webb.
Point of order. I seek leave to table a document. It's a letter from the law firm of Lane Neve outlining the legal costs which would be likely incurred when incorporating a credit union.
Leave is sought for that course of action. Is there any objection? There appears to be none. It can be so tabled.
Madam Chair.
I call David Seymour.
Thank you, Madam Chair. And it would be interesting to see the letter that the member has just sought to table. But I just put it to him this. The people who operate the credit unions, they're the ones who bear the costs. And if people in this committee want to ask themselves who to believe about what the costs are, should it be a law firm best known for setting up that member's superannuation trust in Christchurch, or should it be the credit unions up and down the country who have had these costs of incorporation imposed upon them? And I'd put it to the committee and to the people living at home that I'd listen to the people affected by the law, not the people grandstanding on the law. So, Madam Chair, going back to this Part 3A of the amendment that I'm putting forward, it takes us through the current bill and it tells us, section by section, how we make the changes in order that a credit union which chooses not to incorporate may be able to still operate under the law as it exists. So, for example, should a credit union want to, and let me get to the right page, as I said it's quite voluminous, an unincorporated credit union may offer credit union securities. Under the current bill that's proposed, it would not be clear. It would be a requirement of offering a requirement for offering credit union securities would be the requirement to be incorporated. What 146K makes clear is that a credit union that does not choose to incorporate also has that option. Or 146N, for instance, unincorporated credit union may make loans to members. Obviously, that's a very important aspect of being a credit union, is the ability to advance credit. In order for that to happen, you would require incorporation under the bill as it stands. What this amendment does, Madam Chair, is it allows credit unions that have not incorporated to continue doing that. So, Madam Chair, the principle underlying this amendment should be clear and should be simple. It is that if you operate a credit union, for example, if you operate First Credit Union, a very significant credit union in this country, if you are the Police Credit Union, another very significant credit union operating, both of which have supported this particular amendment being put forward, then you will have the option of remaining unincorporated, and the various sections of this proposed amendment will allow you to continue doing business as you always have without the requirement to incorporate. So that's what's on the table, and I hope members will consider it very carefully, because the question when they decide whether or not to support my amendment is this. No matter how trivial they may think the costs are for forcing other people to incorporate, what right do they have to force any cost if it is not necessary and if there is an alternative that will allow both sides to continue operating as they would prefer? And if they think that's an obscure view, I can tell you even the bureaucrats in this city agree with me. They have said that existing credit unions should not be required. Well, it hasn't happened very often. But the officials who were involved in the Select Committee report on this particular issue, and I wouldn't want to name a particular civil servant. I'm not, Winston Peters. But they said that existing credit unions should not be required to incorporate against their will unless there are sound public policy reasons for imposing such a requirement. Well, I have proposed an amendment that will allow them not to incorporate, that will allow those who wish to incorporate to do so. Everybody can be happy under this bill. The challenge is, are members prepared to do the legwork, as I have, in bringing forward the supplementary order paper, to accept that sometimes things are more complicated than they would like, and give those institutions people have come together and formed a choice. Thank you, Madam Chair.
Madam
I
Chair.
call Dr Duncan Webb.
Madam Chair, it's with the